Good morning, everybody. I'm Debbie Faulkner with Burke Faulkner Law. Thank you for joining us this morning. I want to thank each one of you that is logged on this morning to join me. And those of you who have told us ahead of time you can't make it right now, but you're going to log on in the next 24 hours and watch this webinar. I appreciate you too, and thank you for being interested in the topic of estate planning. So this morning, I decided to do this webinar because we've had a lot of inquiries, especially in the light of coronavirus and the ongoing, trauma that it's caused the people and all over the country, all over the world. There's a lot of people concerned and confused about estate planning documents and what you need to have in place to be all set and to take care of your family. One of the things that we do at Burke Faulkner Law is instead of just doing a will or a trust, which takes care of your property after you die or after you're disabled, we also take care of your entire estate plan, which covers your healthcare directives and your financial directive while you're still alive. And those are the documents that, we need right now to take care of us, to make sure that if we do go in the hospital and go under surgery or have something, bad happen in that regard, or we can't access our finances for 30 days, we go into rehab, something happens during your life, that your family has the right documentation to take care of you right now. So I'm going to talk a little bit about the different documents that are included in your estate plan and why you should have those documents in place. So just as a recap, I'm Debbie Faulkner with Burke Faulkner Law, and we're just going over kind of the basics of estate planning and some of the myths and mistakes that people make when doing their estate plan. So the lifetime directives or advanced directives there are 5 of them that are included in your estate plan. And for those of you who are watching, please type out your questions as I'm going along. We are able to answer them in real time, and I'm really interested to answer the questions that you have on your mind, as well as just sitting here telling you what I have to say. It makes it more fun for me to hear from you. Okay, so of the 5 lifetime directives, there's one financial directive, and that's your power of attorney. Most people are familiar with the power of attorney, but there's a couple things that distinguish your power of attorney in Florida. The power of attorney, generally speaking, is the document that names an agent to act on your behalf for all financial decisions. In Florida, the document is live the moment you sign it. So it used to be the law before 2011 that if you had a power of attorney, you could have that power of attorney take effect in the future. Like, for example, I name my mom as my power of attorney, but only if I become disabled or I have a mental impairment. That is no longer the case in Florida. And I have a lot of people come in and they say, well, I just want to make sure that this takes effect, when I'm disabled. And that's simply not even permitted at all in Florida anymore. So when you sign your power of attorney, it's live. The person that you name can go down to your bank, submit that power of attorney, and wipe out your bank account. The person that you name can sign away your house and sell your house from under you. The power of attorney is all-encompassing, and it covers all of your financial items of value. So that can include things like you're opening your mail. Your power of attorney is allowed to open your mail, file your tax return, receive your tax refund for you, file for unemployment benefits for you, or federal benefits or government benefits of any sort. Your power of attorney can mortgage your property, can get a loan on your behalf. Now, a lot of the financial institutions, the banks, put some regulations in place internally to protect you as the consumer from being taken advantage of by your power of attorney. But legally speaking, in Florida, the moment that you sign that power of attorney, your agent can do all of those things without consulting you first. So I advise my clients always, if you're going to name a power of attorney, you must trust this person implicitly with everything that you own. If you do not have that level of trust with another person, it is advised that you do not sign a general durable power of attorney, but that you sign something a little bit more tailored to what you might need. So a lot of there's a lot of abuse that happens with powers of attorney. And so it's very important that you understand when you sign it that it is essentially the keys to your financial kingdom given to somebody else who can access everything of value in your life and can dispose of those items without your permission, because the document itself acts as permission. Now, sometimes I get the question, well, if that's the case, I really don't want anybody to have that power right now. But if I end up in the hospital or end up disabled, I want that paper to exist. So the way that we kind of work around the law is we have our clients sign the power of attorney, but essentially keep it locked up, just like a will would be locked up, because the person obviously has to have access or a copy of that document to be able to use that document. So if you want to have a power of attorney for the future, you will sign the document, name the agent, and then basically hold that paper in a safekeeping place so that your agent doesn't have the power to go to your bank right now and wipe you out, but that it's in a safe place that can be accessed if something does happen to you in the future. So thank you all that just joined us. Please subscribe to our channel if you get a chance so that you can be updated with upcoming webinars. All right, so that's the one financial directive. There are 4 healthcare related directives. The easiest and most commonly known one is your HIPAA release form. You basically sign this document at all of the different various physicians that you have. Our document names your power of attorney, your financial power of attorney, your healthcare power of attorney, called a designation of healthcare surrogate, in the document, and indicates that the agents that you name in those positions will have access to your federally protected healthcare information. HIPAA regulation requires that form to be separate, or we would kind of lump it in with another form, but it's separate due to federal law. The next form is your designation of healthcare surrogate. This form is particularly important right now if you are concerned with healthcare and coronavirus. I just had a friend test positive for coronavirus. She's, I think, the second person that I know that has coronavirus. Your healthcare designee, sometimes in other states it's called a healthcare power of attorney. In Florida, it's called a healthcare surrogate, is the person that you name to make healthcare choices for you if you are unable to do it for yourself. So for example, you may go into elective surgery or unnecessary surgery and be under general anesthesia. If if let's say the surgeon found something that they needed to take out that wasn't originally on a consent form, your healthcare surrogate is a person that can decide, okay, yes, go ahead and do what you have to do, or no, we don't want that type of invasive procedure done. Your healthcare surrogate, it kind of covers all your general healthcare decisions, but it only takes effect if you are unable to speak for yourself. So that's completely opposite of the financial directive. So your power of attorney takes effect right away. Your healthcare surrogate takes effect only if you are unable to make a healthcare choice on your own behalf. So that takes care of the power of attorney, the HIPAA release form, which is a federal form, your designation of healthcare surrogate. The next form is a living will. A living will is unlike a last will. So there's confusing terms in the law as usual. A last will is, what you think of when you die and you leave property to your beneficiaries. A living will is what I call the Terri Schiavo document. It is the document that says whether you want to be artificially kept alive or you would like to pass of natural causes. And it takes effect in 3 different situations. The first situation is when you are have a disease or an end-stage condition from which 2 certifying physicians have said that you are never likely to recover from that situation. The second is if you have a terminal condition. So the difference between those, an end-stage condition is something like internal failure, like kidney failure, and a terminal condition is like terminal cancer, or you're in a persistent vegetative state. If you have one of those three conditions and there's no treatment available that will ever make you recover from that, you're essentially hospice eligible. The living will is a directive that your family can rely on that says, please let me pass away naturally and do not provide life-saving treatments to me when I'm in those conditions. Okay, so I have a question on the screen. If my wife and I want to come in and talk one-to-one about our estate planning, how would we do that? Great question. You can give us a call at 727-939-4900, 727-939-4900, and we can make an initial consultation to discuss your specific needs. All right, and so the living will is the fourth document. The final document is called a pre-need guardian form. And this is the form that causes the most confusion at meetings because it is such a kind of a bizarre document. What it does is it says who you would like to take care of you if you have to be named a guardian to care for you permanently. Usually this takes place if you have advanced dementia or Alzheimer's and you're no longer able to care for yourself. So in the other situations, with the power of attorney and your healthcare surrogate, you are still competent. If a court is stepping in and naming a guardian to take care of you, this means that you're no longer able to handle yourself. So, for example, I had a client who was, 80-something years old who believed that he was an active duty military member at that present moment. Well, his short-term memory loss caused him to be a danger to himself because he was giving away checks to various different women, claiming to be his girlfriend. He didn't remember one day to the next what he was doing. So in order to protect him from himself, he had a court-appointed guardian. The pre-need guardian form we do here names the people that you would want to be named so that there's no argument in court. There's no latitude for somebody to say, hey, I should be the guardian and that person shouldn't. Okay, question on the screen. In a living will, can you name more than one person? Great question. Yes, you can. Usually in a living will, a designation of healthcare surrogate, we try to name people in an order because if you think about it, if a physician is relying on this paper to call somebody to make these decisions for you, it is easier for a hospital provider or somebody who doesn't know you to call one person first, then the next person, whoever's readily available. So I always advise to do like in a specific order, 1, 2, 3. But, there's no rule against having more than one person serve at the same time. Okay, so those are your 5 advanced directives that are included in your estate plan. And then your estate plan is rounded out by a will or a trust or both. So one of the differences between a will and a trust is that a will is independent. So you can write a will and you can have that will stand on its own, and it does not need to have any other document to support it. I have another question on the screen. In a pre-need guardian document, can 2 people both be listed to serve at the same time? Yes, they can. So in a pre-need guardian, typically what we do is we say that this person is designated to take care of financial choices for the ward, the person who's under guardianship, and this person's to handle their care. But you can name 2 people to handle each position. Great question. Okay, so a will stands independent. If you have a trust, you also have a will. And what the will says is that everything that is not in my trust when I die is poured into my trust after my death. It's called a pour-over will. It's a very specific type of will that's not, what we commonly think of as a will. When you commonly think of a will, you think, okay, I write up a will. It says, here's my family, here's my kids, here's my grandkids. I'm giving this much to my kids, this much to my grandkids after I die. If you have a trust, which is the other way of leaving money to the next generation or to whatever named beneficiaries you would like, your trust takes effect if you become disabled or if you pass away. But so a trust, unlike a will, does not cover everything in the universe that's in your name. So for example, if I die and I leave everything by will, anything that's owned by Debbie Faulkner in the whole world is covered by my will. But my trust, if I have a trust, the only thing that the trust applies to is what I put inside of it. So I'm going to use a metaphor that kind of brings this more to light and makes more sense. If you write a trust, it's not only the legal written contract that we write together, but it's kind of operates like a bank account. So if you go down to Chase Bank or whatever bank, Wells Fargo Bank, and you open an account, they give you a contract and you sign that contract. And it says your responsibilities and the bank's responsibilities and who's supposed to do what, and that they pay you no interest on your money, and you're supposed to put money in the account, and these are the rules. That's kind of what a trust document is. It's a contract. But if you go to your bank and you put no money in that account, the contract still exists and it's still valid, but there's no money for it to control. That's how a trust works. So in order for my trust and what I write in there to take effect, I have to put money in there. A trust kind of has its own identity. So it's like a shadow of yourself. So if I want to put my bank account in the name of my trust, I go down to the bank with a copy of my trust, a short form copy of my trust, and I say, I have a trust and I want my account to be in my trust. The bank will write on the account, instead of Debbie Faulkner, it will be the Debbie Faulkner Trust, and that'll be the name on my account. It still uses my social security number until I die. But this way, the bank is on notice that I have successor people in line to take care of that account if I pass away. Now, obviously, that process is more complicated than just writing a will. So why would you want to ever do that? So one thing about wills that is commonly misunderstood is that all wills go through probate court unless all of your assets are otherwise provided for. So that's a little bit confusing, because a lot of people say, well, my parents had wills and, when the first parent passed away, nothing happened. So if your will passes property to the next generation or to somebody else, it goes through probate court to pass the property. But there are 3 ways that your property does not go to probate, even if you don't have a trust. Okay, so a trust typically avoids probate, which is one of the main advantages of having it. The other way is if you have all accounts taken care of outside of probate. Number 1, if you have joint bank accounts or joint accounts of any kind, they will pass directly to the other account owner outside of the probate court. So this is what happens when there are, long-standing married couples. They've been married 60, 70 years, whatever, 50 years. They typically have all joint assets. So if the first one dies, it automatically passes to the other survivor. This is very uncommon with younger people and, baby boomer generation. We're on second and third marriages a lot of times, and not all assets are joint. Number 2 is if your assets are beneficiary designated. If they're beneficiary designated, such as your IRA or your 401k, pension plans, they will pass immediately after the account holder, the fiduciary, receives the death certificate and the driver's license of the beneficiary, and they fill out a form. That will pass directly, and the court does not need to be involved in that process. And the third way is if you own real estate and your real estate is jointly titled with right of survivorship. If you purchase real estate in the state of Florida as a married couple, you own it in a form called tenants by the entirety. This is a creditor protection that you have. It's a default rule that your beneficiary is your spouse, and that they will receive that property outside of probate. So in sum, if property passes through a will, which means that it is not jointly titled or beneficiary designated or jointly held real estate, then the will go to probate court, and all the assets will go through probate court before they go to your beneficiaries. So some of the advantages of probate is that it is overseen by a court. So if you have concerns about beneficiaries, fighting or, having issues with one another, there's a third party supervising the process of moving property. The disadvantage of having that is that, there's government involvement in your affairs. Your will is public. And so anybody who has access to the court can just go down to the courthouse and submit a request to view your will and see everything that you wrote in there. So it becomes a public document. And then one of the other disadvantages is that it's a lot easier for heirs to start a fight because there is already a court proceeding open. So let's say somebody says, hey, I didn't get my fair share, I don't like it. They can file like a contest the will a lot easier if there's a probate proceeding open. A trust proceeding, on the other hand, let's say you have all of your assets either beneficiary designated to your trust, or you have funded your trust and put your house there, or put your bank accounts there, you've beneficiary designated accounts there. So all of your assets are through the trust and not through the will. There's no court involvement. So the advantage is, your beneficiaries receive money quicker. There's still a process that goes on. If your account's at Fidelity, we have to, transfer it. If it's already in the trust, then there's a matter of just submitting a form that says this is the successor trustee, the person who's after yourself, to be able to take care of the affairs. And then they're able to access it right away. If it's an IRA or 401k, those stay in your name until you die. So they're beneficiary designated to the trust, and there's a process that goes on to move it to the trust, but it's all outside of the court purview. So it takes a lot less time. It still takes some time, but it takes a lot less time to move the money to your beneficiaries. The other big advantage, other than avoiding probate, that goes along with the trust is that if you have any interest in passing money to your beneficiaries over the course of years or over the course of time with certain restrictions, you want funds to be applied a certain way, you want them to be spent on certain things, those are all things that cannot be done through a will. There is one type of will that creates a trust within the will that is available to be able to do this. But the disadvantage is if you create the trust within a will, your family goes through the entire probate proceeding first and then a trust proceeding after. So I never do that sort of trust plan because it's really disadvantageous to your family and really just not good for you either. Now, another word about probate. Both probate and trust administration cost money, but probate does get rather expensive. Most probates that we have here are $7,000 or something like that. So there are a lot of attorneys that you may find that do very low cost wills or free wills. I've seen attorneys give away free wills with any other project that you do with the attorney because they know that in the end, the statutes in the state of Florida provide that the attorney is welcome to charge 3% of your entire estate. You can do the math. It's $3,000 on every $100,000 of value. And that's considered reasonable automatically by the court. And then they are also welcome to charge additional costs for dealing with a house, for example. If anybody contests anything, it gets to be a lot more money. Probate will contests cost $30,000, $40,000 a lot of times. So just a word about that, because I've seen and had some questions about, getting those low cost, low dollar wills. The other thing in Florida, sometimes people do want to do it yourself. Do-it-yourself wills are available online. There are a lot of traps for the unwary. If you do not execute the will perfectly in accordance with Florida law, when you die, your will be tossed away and none of the provisions will apply. So sometimes people think, well, if I don't do it exactly right, the court will read what I want and apply that. That's not the case in Florida. If your will is not done correctly, or if you had it done in another state and it is considered not good in Florida under Florida law, the whole will is treated as if it does not exist at all, and the law applies to your assets. So that means if you're, married, half goes to your spouse, half goes to your children. If you have all children in common, it all goes to your spouse. And there's an order of succession that's very, very long. Okay, so a little bit about trusts. Trusts are, like I said, if you have a desire to leave money over the course of years or over the course of time or with specific restrictions, that a trust is for you. Also, if you have a special needs beneficiary, it is essential that you have specific needs language in your trust for your special needs child so they do not get kicked off of any public benefit that they may have now or in the future. Trusts also allow you to plan for pets. So, in my case, I have a fur baby. I don't have real babies. So in my trust, I plan, give a specific amount of money to one of my beneficiaries who's going to take care of my dog. And that's the money that they have to take care of my dog for the rest of her life. So special needs beneficiaries, minor children is another strong reason to have a trust. In a trust, you can name the people who you want to take care of the finances for your children and also the guardianship of your children. But, you can also basically specify exactly what you want the money to be spent on. So if you have minor children, a lot of times we recommend doing like a 3-tiered system within your trust that says, right now, if we pass away while our children are under 18 years old, for example, we want the guardian, the trustee of our children's money to provide for them in a well-rounded manner. We want our children to be well-rounded, so we want money to be spent on extracurricular activities. Perhaps you want them educated in private school. You can specify, with some specificity, as much as you would like and you feel comfortable with. You can name a different person to be in charge of money than you name in charge of your children. So, for example, you have somebody who you believe would be better for their care, but you have another person who would be better with the finances. You can have that check and balance system in place. And then, after they're 18, maybe we say, money shall be spent from 18 to 22 on any educational pursuit our children wish, whether it's trade school, vocational school, or traditional college, university, and all other sources of income and scholarship shall be considered, and then money should be available to our children for those things. You can say if our child gets married, has a baby, starts a business, etc., we want the trustee to consider giving them extra money. And then at a certain age or at a certain place in life, you can say, okay, I want my children or beneficiaries to have everything at this point. So that's, some of the advantages of having a trust. If you have if you have something ongoing like a business, sometimes a trust is also a way that can continue to be managed over the course of years. But if you have businesses to plan for, we typically recommend that we view the businesses in a different light, and we provide for them within the corporate documents or corporate directives, shareholder agreements, and that sort of thing, and we coordinate that with the estate plan. So there are very specific considerations if you have a closely held business that you need to pass on to your heirs. Some things just we have only a couple minutes here. Oh, I have a question. Okay. Nope. Okay. So one of the things that we do here, I see a lot of mistakes made with some other estate planning documents, is that people don't plan for, the death of a beneficiary. So they say, okay, X amount of dollars goes to Jane Smith. But it doesn't say what happens if Jane Smith is not alive when you die. So, we try to plan here for at least 3 different beneficiaries in a row so that that situation is already taken care of in case you never redo your documents. Okay. Can you name a person to help your children who are 18 years old? Absolutely. So you can absolutely provide, if you can put money in trust for your children and not have them have any access to that money until they're 50, if you wish to do that. Or you can have your children serve as co-trustee with another person who may be a little bit more responsible at that age with their money. So sometimes we have that system set up where, okay, from until 18, somebody takes care of their money entirely. At 18 to 25, their children serves with another person, and the other person has the final say if there's a disagreement. Then at 25, they have access to take over, something like that. If you don't want them to ever have access to money, which happens a lot because there are people that are irresponsible with money, you can name a trustee for the rest of their life. And that trustee can dole out the money when the trustee feels that the person needs it and that sort of thing. So you have all different options within your trust plan. So I'm just coming to the conclusion of this seminar. I hope that you learned something new about trusts and estates and wills. If you guys have any questions, please email me or call me. Our number is 727-939-4900. And subscribe to our YouTube station so that you get updates for our upcoming seminars. There's one more question on the screen. What is the difference in cost between a will and a trust? That's a very good question. So it depends. At least here we do flat fee. We don't do hourly at our firm. And we have a schedule of fees, and it depends on whether you are doing a married couple plan or a married couple complex plan, which is when people are divorced and they have multiple trusts that we have to draft, or whether you're a single person. So we can email you out the schedule of fees. Just send us a quick email and we'll send that over to you right away. So you can call us at 727-939-4900. You can email me any questions you have at Debbie, Debbie, at BurkeFaulknerLaw.com. That's BurkeFaulknerLaw.com. Thanks, everybody. I hope you enjoyed the seminar. And guys, if you have any topics that you wish for me to cover in future webinars, send me an email. I would love to answer your specific questions, go over topics that are interesting to you. You know, it's a guessing game on this side unless I hear from you. So please email me about topics you'd like to hear in the future, and I look forward to seeing you next time.